My name is Kate Bowden, and I am a staff attorney with Disability Rights Rhode Island. I'm here today to talk to you about legal requirements for effective communication in the healthcare setting. So we'll start off with a legal disclaimer. This presentation contains general information about the law and legal practice. So it shouldn't be considered legal advice, and it means that you should not rely on this information as an alternative to seeking advice of counsel or speaking to management where you work in healthcare. A little bit about Disability Rights Rhode Island. So we are a federally funded nonprofit. Our mission is to assist Rhode Islanders with differing abilities in their efforts to achieve full inclusion in society and to exercise their civil and human rights. And we do that through the provision of legal advocacy. Disability Rights Rhode Island is part of a national network. We're called the Protection and Advocacy System, or the P&A, and we were created by Congress. And we exist in every state and territory to help secure and advance the rights of people with disabilities. So there are 57 P&As in each of the states and the US territories and District of Columbia. We help people with individual cases. We provide education to people, and we also work on some large systemic issues. So I want to share with you what some of those have been of late. So systemic issues we're working on. One of them is improving behavioral health care for prisoners who have mental illness in order to eliminate the use of solitary confinement. So we have a large project in Rhode Island on that issue. We're also interested in reducing unnecessarily prolonged hospitalization or other institutionalization for people with disabilities. Sometimes a person with a disability will be hospitalized for a period of time, and then there's no community placement for them, and they stay too long. So we're concerned about that. We're also working to educate the community about a new alternative to guardianship. This is in state law, and it's called supported decision making. And this enables people with disabilities to get support and help for making decisions in their lives, and also retain the right to make decisions instead of taking away their right to make decisions, which is what happens with guardianship. We're also working to ensure that people with disabilities are fully able to participate in voting. So we work on voter education, we have a voting hotline, and we work with election officials to make sure that voting is accessible for people with disabilities. So turning to effective communication as a legal requirement. The law requires healthcare providers to ensure effective communication with deaf and hard of hearing patients and their companions by providing interpreter services and other appropriate auxiliary aids and services. I'm going to get very detailed and go through all the definitions of what that means. But the bottom line is that it is everyone's responsibility to ensure effective communication with patients and companions in healthcare. So effective communication means communication that is as effective with people who are deaf as communication with people who are not deaf. If you were to have a complex, back and forth flowing conversation with a hearing patient about a particular matter, attempting to use written notes with a deaf patient about the same matter would very likely be a violation of the law. So let's talk about the laws that are at play here. The Americans with Disabilities Act is the first one. It's often referred to as the ADA. So the ADA prohibits discrimination and ensures equal opportunities for people with disabilities in employment, in state and local government services, and in public accommodations, which is Title III. Title III of the ADA covers public accommodations that include a range of healthcare entities, such as hospitals, nursing homes, and professional offices of a healthcare provider. The basic mandate of the ADA is equal services. So the general principle underlying the ADA is that no person should be discriminated against on the basis of their disability in the full and equal enjoyment of goods or services, facilities, privileges, advantages, or accommodations of any place of public accommodation. Section 504 of the Rehabilitation Act is also a law that is at play here, and there's also an equal services mandate with that law. So the Rehabilitation Act prohibits recipients of federal funds from discriminating against individuals on the basis of disability. So this act requirements apply to patients and companions that receive medical services from a Medicare or Medicaid provider, not just those whose services are paid for by those federal programs. And finally, the Affordable Care Act is at play here. Section 1557 of the Affordable Care Act contains a non-discrimination provision and regulations about providing equal services. And you'll see in the PowerPoint, I've provided a link to you with a nice summary of the HHS rules on that. So let's look at a companion. I've told you that the law is that healthcare providers have to communicate effectively with people who have disabilities or their companions. Companion means a family member, a friend, or associate of an individual who's seeking access to or participating in goods and services of a public accommodation, who with that individual is an appropriate person for the public accommodation to communicate with. So for example, in a hospital setting, if you would normally speak to the friend or daughter of a patient who's hearing, you would do the same with the companion. And if the companion is deaf, they will need services to communicate. Let's take a look at that term, auxiliary aids and services. So under the law, healthcare providers must furnish auxiliary aids and services to deaf and hard of hearing patients and their companions where it's necessary for effective communication. So no individual can be denied services just on the basis that of the absence of the proper aid or service. So let me give you some examples of what auxiliary aids and services are. An in-person sign language interpreter, so someone who's in the room to interpret, is an example of a service, an aid or service under this law. Another example is a sign language interpreter that is used through video. That's called video remote interpreting, and it's often referred to as VRI. There are many other types of auxiliary aids and services that are listed in the law, and I have some examples for you. Some of them include telephone relay service, hearing aid compatible telephones, video phones, and written notes. So coming back around to VRI, I want you to be aware that there are some challenges with VRI. You should know that sign languages are visual languages, and they are three-dimensional languages. VRI interpretation happens through video. It is much smaller, and it is in 2 dimensions. So when you're using only 2 dimensions, it takes something away from the language. It's like the smaller size is like a quieter voice or a smaller print. So this can make sign language harder for someone to understand through video than in person. And for all these reasons, you should know that someone who is sick or upset might have trouble understanding a video interpreter, and they might really need a live interpreter, live in-person interpreter instead. So let's unpack this term, effective communication. Entities must ensure that communication with people with disabilities is as effective as communication with others. So the type of auxiliary aid or service that's needed to provide effective communication will vary depending on the specific facts and circumstances that you're presented with. As an example, a person who is deaf might be able to read English really well and would not need an interpreter to review informed consent paperwork. On the other hand, a different person who is deaf, who does not read English at all, would need an interpreter for reviewing informed consent paperwork. So violations of the law happen when the healthcare provider fails to provide auxiliary aids and services to a deaf patient or their companion when it was necessary to ensure effective communication. And what the courts look at here is ineffective communication occurs if the patient or the companion experiences a hindrance because of their disability, which affects the ability to exchange material medical information with the healthcare provider. So the focus is on, was there a flow of information that was able to occur? Patients and companions do not have to show deficient treatment or poor medical outcome to prove that their rights were violated. What we look at is the focus is on the ability to exchange relevant medical information. So there's another term that's important to understand here, and that's called primary consideration. When the healthcare provider is determining which kind of communication aid or service to furnish to the patient, the healthcare provider must give primary consideration to the request of the deaf or hard of hearing patient or companion. This means that staff should honor the deaf or hard of hearing patient's or companion's choice for communication services, unless there is an equally effective means of communication available, or the means that they chose would result in an undue financial burden. The obligation varies depending on the financial resources of the healthcare entity. So what that means is the law would look differently on the level of services that a solo practitioner needs to provide versus the level of services that a hospital should be prepared to provide at all times. And important to note that this requirement to honor the choice of the person who is deaf comes from the Affordable Care Act, the primary consideration requirement. So let's pick apart these aids and services and what's appropriate. How do you know what's appropriate? The aid or service must work for the individual. So exchange of notes may at times be effective and therefore appropriate for simple communication and in situations that do not involve substantial conversation. For example, when blood is drawn for routine tests or if someone is getting a regular allergy shot. In determining whether a communication service is equally effective, the provider has to consider the nature, length, and complexity of the communication at issue. So there are certain situations, and I'm going to turn my attention to the hospital setting here. There are certain situations where an interpreter most likely is required in order for effective communication to happen. These include discussing a patient's symptoms, medical condition, medical history, or complex billing or insurance information, explaining and describing medical conditions, tests, treatment options, medications, surgery, or other procedures, providing a diagnosis, a prognosis, or a recommendation for treatment, obtaining informed consent for discharge instructions, and communicating with the patient during treatment, testing procedures, or during a physician's rounds. These are all complex topics where communication is essential, and effective communication may require the higher level of aid and service. And I'll tell you a quick story. I worked with a man who was deaf. His brother was the patient, and his brother was incapacitated. And the hospital was proposing removing the leg of the patient. And the deaf man was required to sign off on informed consent paperwork without an interpreter. He didn't fully understand everything, and he was very much traumatized by this experience. So these decisions are important, very important decisions. And that brings me to a note about people who use sign language. People who communicate primarily by sign language may not understand spoken English. Sign language is very different from spoken English. So it's important that you do not assume that they can read your lips, and you do not assume that they can communicate through writing. Another point is healthcare providers should be very wary of relying on lip reading and gestures for a person who communicates primarily in sign language. Studies have shown that even in optimal conditions, 30% or less of the content of a conversation is understood when relying on lip reading. So, failure to comply. Ensuring that a patient or her companion is provided with the right auxiliary aid at the right time is not just best practices, it is required by the law. And the consequences of failing to provide appropriate auxiliary aids and services can be truly significant. They include adverse health outcomes, trauma, lack of trust in the healthcare system, medical malpractice, and lawsuits and legal liability for the healthcare provider. Common issues that we see in lawsuits. Failure to obtain an in-person interpreter when it was needed. Enlisting family members, friends, or unqualified staff members to facilitate communication. VRI issues. The staff doesn't know how to set up the VRI, or the VRI system is not working. Inappropriate reliance on handwritten notes for individuals whose primary means of communication is ASL. Erroneously assuming that an individual who is deaf or hard of hearing can read lips and does not need an auxiliary aid or service. Or refusal to provide aids and services due to cost. So those are all facts that have come up in lawsuits where liability was found for the healthcare provider. So I've given you a lot of information, and now we'll put this information into practice with some fact patterns for you to consider. Our first fact pattern is a hospital ER emergency room policy provides that a woman may bring one person into the operating room for her C-section. This is the +1 policy. During her C-section, a hearing woman would be able to communicate with her healthcare providers and her companion. A deaf woman who communicates through American Sign Language needs a C-section. She is informed of the 1+ policy, the +1 policy, and she's advised that she will have to choose between having her husband or her sign language interpreter in the operating room during her C-section. Given what you know now, is that the right approach with this patient? The answer is no. Asking the deaf patient to choose between her husband or her interpreter would be a violation of the law in this situation. The hearing patient was allowed a companion for support and was allowed to communicate with staff. So providing equal services in this case means allowing the deaf patient to have a support person and a means of communication. The deaf patient should be allowed to have her husband and her interpreter in the operating room. Okay, your second fact pattern. You are discussing the plan of care with patient Pat, who is deaf and uses sign language. You are using VRI to communicate, the interpreter through video that I've mentioned. Pat says the VRI is not working well and he would like to have an in-person interpreter. You check the VRI, which seems to be working fine. What do you do? Do you A, continue with using VRI because it seems to be working fine to you? B, immediately contact tech support to fix the VRI issues? C, stop using VRI and write notes with Pat? Or D, contact the interpreter services department to request an in-person interpreter? The answer here is D. You should contact interpreter services and secure an in-person interpreter. And why is that? The law requires the hospital to give primary consideration to the choice of service of the patient. Deaf people are in a better position than hearing people to identify if VRI is working well because they are using the visual component and we are not. Because Pat has requested an in-person interpreter, it must be provided, especially because the VRI is not working well. Finally, if Pat had not requested an interpreter, it would be okay to contact technical support to fix the VRI, but if they couldn't fix it quickly, you would be wanting to look to offer an in-person interpreter or other aid that's appropriate and works for Pat. Okay, our final fact pattern before we close. Patient Paul comes into the hospital with Diane, his adult daughter. Diane is deaf and Paul is not. When you communicate with Paul, you notice that he is signing with Diane. Paul tells you that he brought Diane so that she can help him understand his care and treatment options. Do you do nothing because Paul seems capable of making his own decisions without Diane's input? Do you offer Diane interpreting services? Option B. C, ask Paul if Diane needs an interpreter. Or D, do nothing because if Paul or Diane wanted an interpreter, they would request one. Answer here is B. You should offer Diane interpreting services. What you need to know here is that a patient's companion does not need to be a decision maker to qualify for interpreting services. And because she is deaf, Diane alone and not Paul has the right to decline interpreting services. Even without the request, it is best to offer interpreting services in this situation because not everyone is aware of their rights. And because Diane is Paul's daughter and someone with whom the hospital would normally communicate, the hospital should offer interpreting services in order to communicate with Diane. So those are your fact patterns. And I will just conclude by encouraging you to make sure that you know and understand the policies, procedures, and protocols for obtaining an in-person interpreter or other auxiliary aid in the healthcare setting where you work. Make sure you know how this works where you work. Ensuring communication that allows healthcare staff and deaf and hard of hearing patients and companions to exchange medical information is really part of providing quality healthcare, and it's also required by the law. So finally, I would like to give a special thank you to the Department of Justice and the National Association for the Deaf. They helped me find resources to put this presentation together for you. And in your final slide, you will see resources. You can reach out to Disability Rights Rhode Island on our website or by phone if you have questions for us. And feel free to check out the National Association of the Deaf website and the Department of Justice website and send us any feedback that you may have. I thank you for your time and goodbye.